order to visit Canada as a visitor, you must abide by the immigration laws that are in place to ensure the safety of Canadian citizens and permanent residents. If you are deemed inadmissible to Canada due to a past criminal offense made in or outside of Canada, and you would like to overcome your inadmissibility, you may apply for a criminal rehabilitation application. However, it is extremely important to note that this is not a permanent solution, and if you were to re-offend, then the criminal rehabilitation would become void. In this video, I will explain the eligibility requirements for a criminal rehabilitation application, how to apply for a criminal rehabilitation application, the specific documents that you will need, and the chances for a successful application. In order to apply for a criminal rehabilitation application, you must be first inadmissible to Canada. Most of the time, this inadmissibility is due to a past criminal offense. Any foreign national that has a criminal offense in the past may be deemed inadmissible to Canada and will not be allowed into the country. Furthermore, I will list the certain circumstances that would entail criminal admissibility. You are deemed inadmissible if you were convicted of an offense in Canada, you were convicted of a crime outside of Canada that is considered a crime within Canada, you committed an act outside of Canada that is considered a crime under the laws of that country, and would be equivalently punishable under Canadian law. It is always important to acknowledge the time frame since your previous offenses. In order to be eligible for a criminal rehabilitation, a minimum of 5 years must have elapsed since the last offense. Additionally, the 5 years would start on the last date the sentence was imposed. If you have not completed the specific time frame, then you may not apply for a criminal rehabilitation. The application for a criminal rehabilitation is extremely beneficial for any applicants that would like to rid themselves of their criminal past in order to enter Canada. The foreign national that is applying for a criminal rehabilitation is essentially asking the Canadian government to pardon them or forgive them of their previous offenses committed in a foreign country or within Canada. The moment that the Canadian government forgives them of their previous offenses, then their previous offenses will not impede on their entry into Canada. The application process for a criminal rehabilitation will require forms and documentation to be provided to Immigration Canada. The forms would be provided to you on the government website or by Akrami and Associates, of course if you decide to retain our legal services. Keep in mind, when you are applying for a criminal rehabilitation and asking the Canadian government to forgive you of your past offenses, it is very comparable to presenting your case in court and trying to prove your innocence. You must provide sufficient evidence that your lifestyle has changed and that you have completed all of your specific sentences. Therefore, the required documentation for a criminal rehabilitation application are passports. If you do not have a passport, then you can provide your driver's license or your birth certificate. Court judgments made against you. These documents will show the charge, the section of the law under which you were charged, the verdict, and the sentence. Canadian equivalent laws under which you were convicted or charged. Any documents that relate to the probation, parole, sentence, or pardon. These documents will include court records, judge comments, probation or parole record, certificate of rehabilitation, and more. Criminal clearance from police. These can include anywhere that you have lived for 6 consecutive months or longer, and specifically for U.S. citizens, state clearances. These can include any states that you have lived in for 6 consecutive months or longer. Conclusively, the more information and documentation that you provide to an immigration officer will result in a stronger case and a better chance for approval. If by chance you cannot provide a certain document or certain documentation, then it is always advisable to provide an explanation as to why you cannot provide these documents. However, this may impede on the chances of success, and I highly recommend that you try your best to gather all of the required documentation. In order for you to have a successful chance of gaining entry into Canada through a criminal rehabilitation application, you must ensure that you have a well-prepared and compliant collection of forms and documents, as well as an exceptional submission letter to prove and explain why you should be let into Canada and forgiven of your prior offenses. By submitting all of this information to the immigration officer, they will ultimately have the discretion to let you enter Canada or deny your entry. They will essentially review all of the information and documentation that you have provided and will consider a number of factors. The specific factors that the immigration officer will focus on are the number of criminal offenses that you have on your record, the seriousness of each offense committed, your explanation of each offense, your behavior since each offense, the reasoning of why you are unlikely to reoffend, your present circumstances and lifestyle, support you receive from your community, and lastly, reasoning for why you believe that you are rehabilitated. It is essential that you have taken all of the aforementioned information and documentation into consideration prior to applying for a criminal rehabilitation application. Here at Akrami & Associates, we have dealt with many immigration matters, and we have helped many of our clients gain entry into Canada as visitors. Therefore, if you feel like you would be eligible for a criminal rehabilitation application, please contact us. With Akrami & Associates, there's always a way.